I'm here for special appearance.
All right.
Are we on the record?
Call your case. We're not on the record yet. This is City of Antigo versus Derek Sprague, case number 20-FO206. City appears by Assistant City Attorney Courtney Imig by telephone. Mr. Sprague is here in person. Mr. Sprague, it looks like you have a recording device on the lectern with you. Is that correct?
I'm documenting as per my First Amendment right, is the course of everyone's duties here, my right to document my interactions. I shouldn't need to ask for permission to exercise the right.
All right. First of all, I asked you if you are recording these proceedings. Could you answer that question, please? You don't wish to answer that question?
I plead the fifth.
All right. It appears that you are recording these proceedings, Mr. Sprague. I generally allow that, but a request must be made to allow that and a reason stated therefore. Are you requesting to be allowed to record these proceedings?
I am requesting for the rest of my life to not have to ever ask for permission to exercise one of my cemented and unalienable rights. There is not an agency or an entity on this land or of this land that can take a common right away to document. My First Amendment rights are also part of the Constitution of this landmass. If the court would like to construe it as a request, then I guess I'm making my verbal request for the life to never have to request ever again.
Okay, well, I'm not going to approve it ever for the rest of your life. I will allow you to request it at the beginning of each proceeding, as long as it's not a distraction or interference with the administration of justice in this courtroom. I would generally allow it. I will also note that there is a court reporter that works for the state of Wisconsin that is documenting all these proceedings, but I understand some people have trust issues or are concerned that that's not sufficient, so that's why I generally allow people to record.
I have yet to have any of my public records requests fulfilled by any entity of Langley County, so the only legitimate record I have is right here. So it's going to stay on just as always to keep my records documented and secure. Not trying to hinder the court in any way. There was more of an issue with acknowledging it than there would have been for the device here operating. Just going to be open about that part. Not trying to be disrespectful, but...
Thank you. I appreciate that.
Yep.
All right. The court will grant you permission to record these proceedings today. And then we'll move on to the purpose of our hearing, which is an initial appearance on a citation for movement, which... Yes, Ms. Imig?
Your Honor, if I may, this citation was issued. However, I have reviewed this citation and I don't believe I can amend it on the record, so a new citation will have to be issued under the ordinance 38-408. So I'd ask that this citation be dismissed at this time.
I would like this entire case to be dismissed. The state doesn't even know what they're trying to charge me with.
Well, all I got is a case that's filed right now, and the city's requesting that case be dismissed. Do you want to say anything about that, Mr. Sprague?
I want it dismissed with prejudice on both ordinances, the 29-131 or whatever it is, and then the 48 or whatever that I believe I'm being charged with this one. I would like it ruled without prejudice. The court and Ms. Imig, operating as a foreign agent in her dual capacity, has absolutely no jurisdiction. There's no merit. She has no legitimate purpose. And I go so far as to quote Miranda versus Arizona, where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. The general misconception is that any statute passed by legislators bearing the appearance of law...
Sprague, can you slow down a little bit so my recorder can get all you're saying?
Sorry. This general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land, and any statute to be valid must be in agreement. It is impossible for both the Constitution and a law violating it to be valid. One must prevail. I also have some more reading. I believe that the court or the case was initiated erroneously, fraudulently, and criminally. I still have yet to have a warrant produced for my property. There is picture evidence that this court has submitted here on record of my property, past no trespassing signs. I've never had a warrant produced. No one's even acknowledged that there was criminal activity. The Supreme Court has held that a public official must obtain a search warrant before entering private property, citing specifically the need to do so before a code enforcement inspection. I may be a little ignorant, but I believe code enforcement inspection is part of what this flimsy unconstitutional ordinance falls under. See Michigan v. Tyler, 536 U.S. 499, 504-508, and then it's got 1978 in quotes, parentheses. While there are exceptions, such as if exigent circumstances exist, the warrant requirement is the foundation of search and seizure law.
Mr. Osprey, I'm just going to interrupt you. How much do you have to read today?
I'm just going through like 2 pages. I'm already done with this
I'll
one.
give you a little bit more time. I will allow you to supplement this in writing, anything else you want to file, but I don't intend to rule on.
No, yep, I'm just trying to prevent future in the court.
So I'll let you make a couple more minutes of record as you wish, and but then I got to move on.
Yep. The warrant requirement is the foundation of search and seizure law and will more often than not control a city's actions in code enforcement. Again, there has been no warrant produced. Roger Loosloff was trespassing on clearly marked private property after his express and implied rights to enter my property were terminated. Cantwell v. Connecticut, 310 U.S. 296, 1940, is a decision by the United States Supreme Court holding that the First Amendment's federal protection of religious free exercise incorporates via the Due Process Clause of the 14th Amendment and so applies to state governments too. The First Amendment clearly gives me the right to express myself, my person, through my property that does not harm anyone. I believe it is my religious beliefs that the property in question should be exempt, should be without prejudice, should be invisible to the state's eyes, and especially the city trying to use these ordinances against my property because they're grossly misapplied, misconstrued, and they're criminal activity because they're depriving me of my property that is not harming anything other than me, the victim, and my property.
All right, thank you, Mr. Sprague. You stated that position on the record. As I said, you may also supplement the record with anything you like in writing by filing in the clerk of court's office. If you do that, obviously, you should send a copy to the prosecutor as well.
How do I go about like a cease and desist on this? Is that something you do, or do I come back for restraining?
Mr. Sprague, that you have to do on your own.
Okay, I would like to ask for a cease and desist right now because this county and the state is trying to erroneously and fraudulently apply statutes with no basis, ordinances with no basis against my property.
All right. You made that request on the record as well, and granting or denying that request today. As far as back to where we were a minute ago on the city's motion to dismiss this, they can dismiss their own citation. I can't force them to keep it alive even if I thought it should, although there is a judge in federal courts that's trying to keep some case alive against some big person. It's kind of a weird thing, but I don't know much about that. So I am granting the city's motion to dismiss this citation against you. For now, that is without prejudice. I will reserve your right to be heard further or to conduct further proceedings on whether perhaps you are right and it should be with prejudice, but I am not granting that today.
Is this court not recognizing basic First Amendment rights?
I will only grant that request if they attempt, I will only consider that request if they attempt to refile it. If they don't attempt to refile it, it's moot. You had a question, Mr. Sprague?
My problem is it should be with prejudice because the city has made it more than clear that their intent, especially Mike Winters, that terrorist has made it clear that he doesn't care about the law, and he's made it pretty clear, as I'm sure you know, I had to write the court a letter to go out of my way to correct a member of the same system that's brought all these actions against me that are clearly frivolous in nature. They're sinister, frankly. I think that the city should not have any power. They clearly don't have jurisdiction over any of the subject matter. I need it with prejudice that my private property will not be the subject of any more of these wastes of court resources.
I respect your opinion and your view of it, Mr. Sprague, and I may ultimately agree with you, but I am not dismissing it without prejudice today. Or, I'm sorry, with prejudice. It is without prejudice today.
That's
and,
unfortunate.
proceedings if necessary. And I believe that's all I really wish to take up today. I'll let you state any additional record if you want to, Ms. Imig, and then I'll let Mr. Sprague have a final say if he has anything else he'd like to put on the record. Ms. Imig, anything else?
No, Your Honor.
Anything else today, Mr. Sprague?
Ms. Imig really should look at Peterson versus Peterson because it seems like there's going to be no remedy in sight, unfortunately, to this unconstitutional crap that's going on against me and my property. Peterson versus Peterson, you really should look at it because it's going to guide everything you do.
But I appreciate that you're trying to insist in focusing on the issue. Could you give the court so Ms. Imig can hear the citation on Peterson versus Peterson?
I just have a summary of my paraphrase my words.
I'll let you do that, but you don't
Nope,
have a case cited?
Nope, I don't have Peterson
Okay,
versus Peterson.
So there's a case called Peterson versus Peterson that says some kind of a...
It says that this court is illegitimate and her as a dual official is a terrorist and a treasonist.
Go ahead and read whatever you'd like to read about that.
The Secretary of the State is the keeper of the evidence of law legislation. In the Idaho Supreme Court case, Peterson versus Peterson, justices ruled that the law is not what's in a law book. The law is the legislative acts with committee meetings, notes, etc., and the governor's signature, which is held in evidence by the Secretary of the State. Guess what? Someone gave all the evidence away to the Historical Society, thus breaking the chain of evidence. Technically speaking, there are no laws in Idaho. I suspect this is in every other state in this landmass. You must challenge jurisdiction. Subject matter jurisdiction is hard to prove. You have to prove it as a member of the court through discovery. I have to demand through discovery, and you have to prove during discovery with certified copies of the law. This is everyone's right to know what they're being charged with and that the law they're being charged with are valid from the Secretary of State if they don't comply. I'm supposed to compel discovery because there is no way that you can prove in writing and give to me in official documents that this court will recognize anything other than an oral motion that you shall stand with jurisdiction, forcing me to make an oral motion to dismiss because per Peterson versus Peterson, you have not produced anything tangible that grants jurisdiction. If they deny the motion, I'm supposed to object, again stating the reason, Peterson versus Peterson, and then keep moving it through to a legitimate court in appeals because this court has no standing because there is no true injured victim.
Thank you for that record, and although there's no citation, you gave us an important hint. You said Peterson versus Peterson is an Idaho Supreme Court decision.
Mm-hmm.
Ms. Ewing should be able to find that and read it in its entirety if she wishes to. All right, then that's all for the proceedings for today, and perhaps permanently, but if a new thing is filed, we'll deal with it as it comes.
And just so for the record, there's another baby going to be in my driveway in about another 2 or 3 days. So just giving everyone the heads up, if we're going to keep pursuing this, I'm going to pursue if my life and my house is going to be trashed. So it's up to you, Miss Courtney.
Don't address her, you'll address the court, please, Mr. Sprague. All right, so thank you for coming today and making your record, and hope we can work this out, but if not, I will do my best to be a fair and impartial jurist and listen to both sides and apply the laws I see that I'm supposed to. Thank you, everyone. We are adjourned.